Hey there, Attorney Andrew Bethel, and let's just jump into it. Today we're revisiting land trust, LLCs, and which is the best to hold your rental property in. I did a video on this a while back. Back then, I was never asked about land trusts though. I had read about them online and here and there, so I figured it would be a nice little topic for a video. However, since then, I've had a lot of people approach me and ask me about land trusts, LLCs, and which is better to hold their rental properties in. Now, was that due to me having put out a video on land trust, or was it because a bunch of other talking heads constantly putting out videos on them? I think it's a combination of the two because I have had people that specifically mention having watched my prior video and others having no idea we even have this channel. Regardless, the main purpose of today's video is to have a straightforward discussion on land trusts versus LLCs and to specifically focus that discussion on California real estate investing. Is this subject well trodden? Yes. Am I likely narrowing the audience for today's video by focusing so much on California? Probably. Am I wasting time asking you these questions? Absolutely. So let's jump in. Right off the bat, I need to give credit where credit is due. There is an attorney here on YouTube, Clint Coons, who runs a pretty large channel and discusses wealth planning with an emphasis on real estate investing and tax planning. He has done a number of videos on land trusts and LLCs. I suspect this is a contributing factor to the amount of people who call and ask me about them. But there is one he did somewhat recently that I want to borrow the basic framework of since I think it greatly hones in on the primary concerns. And those are asset protection, taxes, due on sale clauses, and anonymity. First up, let's talk asset protection, and right off the bat, it's a win for LLCs. Land trusts are typically revocable, meaning that for us here in California, in the context of today's discussion, the only benefit the land trust offers is probate avoidance. A revocable trust in California does not confer any sort of liability protection for you or the assets held within that trust. If you own a property out near Mount Shasta in a land trust and someone slips and falls and then sues you, well, you cannot point to the land trust and say, hey, you're protected. From a liability standpoint, that trust is you and you are the trust, meaning you have unlimited liability. Okay, so perhaps your next thought is to then just create an irrevocable trust and pop the property in there. That'll work, right? Sort of, but I can almost guarantee you'll run in fear of that idea in just a moment. If we put the property into the irrevocable trust, then yes, we are separating the property from your personal estate and thus creating some potential liability protection. However, to have that, one, the property is not coming back to you since you transferred it, and two, you're going to need to give up either the control of that trust or the beneficial interest, meaning you don't get to benefit from the property. Plainly put, the property is out of your hands and you need to either put someone else as trustee, meaning they decide how to manage the property, or you put someone else as beneficiary, meaning they get all the benefits of the property, like for instance, rental income. Plus, to top it all off, because you transferred that property to an irrevocable trust, there are now gift taxes to worry about. Now, depending on the value of the property, we're likely still able to avoid a gift tax, but you would then use some of your lifetime gift tax exclusion amount, which would result in your estate being subject to estate taxes after you die. Contrast that with an LLC. All 50 states and DC allow for the creation of LLCs and they confer some level of limited liability. It's in the name, limited liability company. But what that means is if someone sues due to a slip and fall on my Mount Shasta property in my LLC, then they must sue and can only collect from that LLC, and my personal assets are protected. Of course, each state is going to have its own rules that dictate how far that limited liability goes and what could be done to potentially pierce that corporate veil and thus subject you to personal liability. But the general principles are the same across the nation, mixing business and personal assets, undercapitalizing the LLC, etc. To round out the asset protection discussion, you may be asking if you can create a land trust and then put that land trust in an LLC. Or maybe not, because it sounds kind of strange, but hear me out. You could create the land trust and the LLC and make the trustee and or beneficiary of the land trust that LLC. That way, we get the flexibility of a revocable living trust along with the benefits of the LLC, limited liability. Even then, I'm not 100% convinced that this sort of structure would fully insulate you because at the end of the day, that land trust, if it's a revocable trust, and it likely is, then I could see an attorney doing their best to just bypass the LLC and walk straight up to you to collect from your personal estate because that property is subject to the litigation in your revocable trust, not wholly owned in a separate entity like an LLC. Food for thought though. A potential use for this structure would be that you could then simply amend the trust and make another LLC also a beneficiary of the trust without transferring the underlying property. Essentially, you bring in a business partner through their LLC, but you aren't transferring the property title to bring them on board. However, it's an extra layer of complication that doesn't necessarily do anything extra for you here in California. You can accomplish the same thing by creating the LLC, putting the property in said LLC, and then putting that LLC into your own revocable living trust. Plus, if you plan on bringing in a business partner, then they're not going to go for the LLC as the land trust beneficiary structure, since there wouldn't be anything stopping you from just amending the trust later to cut out the business partner, and they would have no say in the matter. However, it's a whole rabbit hole that's for another discussion. What you need to know is that from an asset protection perspective in real estate investing in California, popping that property into an LLC is going to protect you personally. How about a lighter subject next? Taxes. I know, nobody likes them, and I'm constantly talking about them, but just about anything you do affects some type of tax, so there's no avoiding it, I'm afraid. Here we're going to talk about property taxes, which is a minefield because each state has their own way of handling them. Each state is going to have their own exceptions, their own catch-22s, and their own opaque way of figuring them out. However, with many states, California included, your property taxes are determined based on the value of the property at a certain point in time, such as the time of purchase. There may be some credits applied to it to reduce that number, and some type of limiting factor that prevents the county assessor from raising the property taxes too much over time. In California, we have Propositions 13 and 19, which, wouldn't you know it, I've done a deep dive into property taxes in California and discussed everything you need to know to be an informed property owner in California before. What you need to know, however, is that when you acquire a property, the property taxes will then be typically assessed, and then the county assessor can only increase that assessed value, which determines your tax bill, by no more than 2% per year, except in some very narrow circumstances. What that means is that the longer you've had the property, the more out of step the assessed value of your property will be from the fair market value. It encourages you to keep property you own, because when property is transferred, the county can then reassess the property taxes, bringing them back up in line with the fair market value and thus increasing the tax bill. In some states, transferring your property to your LLC may trigger a reassessment of the property taxes even if it's your LLC. In all the states, however, transferring property to your own revocable living trust, which can be a land trust, does not trigger a reassessment of the property taxes because the property is still yours. It's still part of your personal estate. So where does California line up in all this? Well, the point here goes to both the LLC and the land trust, because in either case, transferring your property to your revocable living trust or to your LLC won't result in a property tax reassessment unless you're adding someone else to the mix and they aren't a spouse. However, there's another tangent and we need to keep moving. There's one thing that I want to tease you about because it's a topic I've been meaning to make a video on. I just haven't made the time to put it together, and that's utilizing something like a step LLC or family LLC structure. In essence, you use multiple LLCs to move property around to bring others into the business, typically your children, and one of the incidental benefits may be that you avoid a property tax reassessment. However, the only aspect of that I want to touch on here is the fact that transferring property into or out of an LLC can trigger a reassessment of the underlying property in California where more than 50% of an LLC holding real property has been transferred. If George R. R. Martin transfers his property called Westeros to his LLC called Planetos LLC, then no reassessment since it's still George's property. If George transfers 50% to Planetos LLC to Paris McBride, then still no reassessment of the underlying property Westeros. However, once George R. R. Martin transfers even 1% more of Planetos to Elio Garcia, then there will be a reassessment of the underlying property Westeros. The county won't necessarily know right away, but once they try to do something with that property, like take it out of the LLC, then the county is going to ask about any ownership transfers and ask for payment of back property taxes. However, we'll save that in-depth discussion for the Step LLC video. For now, just remember that in California, you can transfer your property, whether it be your primary or investment property, to your own revocable living trust or your own LLC and not trigger a reassessment of the property taxes. This next section will be shorter, and that's the due on sale clause. If you have a mortgage on a property, then there's likely a clause in there that specifies that the entire loan is due if you transfer that property to someone else, which 99% of the time is triggered because someone moving and selling their house. Now, this is something that won't really vary by state law, but by your lender. However, in most cases, transferring your property to your revocable living trust or your LLC will not trigger the due on sale clause, and sometimes you may not even have to tell them you did it. This is another one of those instances where so long as you aren't bringing in another person who's a non-spouse, then doing one of these transfers doesn't affect anything, which effectively means another point for both the LLC and the land trust. Next is anonymity, which is a topic a lot of people like to bring up. However, one thing to keep in mind is that it is very difficult to be truly anonymous to the public and next to impossible to be anonymous to the government. Additionally, something you may also need to keep in mind is that if you currently own a property, then your name's in the chain of title and technically viewable to the public right now. If you take that property and put it into a trust or LLC that doesn't have your name on the title, then your name is still in the chain of title and will be on the deed that transfers the property to that entity. Going further, even if you transfer it to a trust or LLC, it's going to be seen as a gift, not as a sale, and therefore obvious that the property is still your property. You could try to characterize that transfer as a sale, but now you're triggering a taxable event between yourself and thus giving the government more money for no reason. Okay, you're probably now thinking, what if I just buy the property directly into the LLC? Well, yes, that would work in that your name won't be on the chain of title, maybe, but we'll come back to that. But you're going to run into an issue with just getting the property in the first place. So what do I mean by that? From experience, title companies don't like and often won't issue title insurance when it comes to a transaction involving a land trust. Additionally, you're going to run into an issue where a lender won't lend to a land trust or LLC, which means you're going to need to either pay cash up front or find a lender who will go for the transaction but will likely charge more to do so. If you've already got cash or other properties in an entity, then you can overcome that hurdle, but it's a big one to jump in the first place. However, let's say none of that is an issue. You've got a few $100,000 lying around and you're ready to begin purchasing some real estate, but you really want to protect your identity, or at least make it very hard to find out it's you behind the curtain. Well, we still have more hurdles to jump through. First is the little matter of the trustee of a trust appearing on the deed to a property and the fact that when establishing your LLC, you turn over a lot of information to the state and much of that is public record. So let's start with the trust. When a property is transferred to a trust, title to that asset is held by the trustee of the trust. To know who has authority to manage that property in the chain of title, the trustee's name needs to be listed on that deed transferring the property to the trust. Thus, if you're a trustee, then we're back to having your name appear in the chain of title, which is what we're trying to avoid in this scenario. All right, there are two potential fixes for this issue: LLC as trustee or a nominee trustee. Let's start with nominee trustee since the LLC as trustee leads us to the next step. A nominee trustee is picking someone to be the trustee for the sake of this transaction, but having them resign as trustee once the property is transferred. What that looks like is Albus creates a trust, let's say the Hogwarts Trust, but he appoints Harry to be the trustee because Albus doesn't want his name on title. However, Harry isn't interested in being responsible for the management of the Hogwarts Trust and the underlying real estate. So Albus says, that's fine, I just need you to be there for the initial transfer into the trust, then you can resign as trustee and not worry about managing assets. So a deed is executed transferring the property from the initial owner Tom to the Hogwarts Trust with Harry as trustee thereof. No mention of Albus whatsoever. However, once that deed is recorded, Harry resigns as trustee and is relieved of his duties. Albus had himself named as the first successor trustee, so he becomes the new trustee of the Hogwarts Trust due to Harry resigning. While in order to do anything with the property down the line, for instance, sell it, Albus would need to file a change of trustee affidavit to formally remove Harry from the chain of title. If the plan is to keep the property long-term for rental income, then Albus just never files that affidavit unless or until he needs to. However, Harry would still be somewhat involved. If one checked the title because they wanted to complain about a barking dog, a crazy party, or even sue the owner, then they're only finding Harry's name and they're going to try to contact Harry. But Harry has resigned, so he isn't responsible for the management of the Hogwarts Trust and its assets. But Harry is going to be contacted about it even every so often. So, in exchange for Harry's name being in the public record and thus the face of the property, Albus might pay Harry a small yearly fee for the trouble in much the same way you would pay a company to be an agent for service of process, as in a lawsuit, for an LLC. A small price to pay for some peace and quiet and some anonymity. Going further, what about the option of having an LLC as the trustee? Now, there's not a name on title as trustee, but an entity. However, we run into the same issue as having the LLC own the property to begin with, and that's the fact that having an LLC means giving information to the state and for that information to be public. Well, if you have ever investigated any of this, then you've likely heard that there are some states that people recommend for anonymity because they don't share as much information publicly. Don't get me wrong, they still collect that information, it's just not as accessible to the public, if at all. So let's talk Wyoming LLCs. Wyoming is the state that is the darling of the anonymous LLC world because while they collect information, they don't publish that information like most other states do, particularly California. Thus, you'll often see Wyoming LLCs recommended for investing in real estate. There's just one issue though. If you own California real estate in a Wyoming LLC, you have to register that LLC in California, and now you're back on the hook for that public information. Well, this is where you start layering these entities again. You could have the Wyoming LLC be the beneficiary and trustee of the California Land Trust that holds the California real property. But as I discussed on the asset protection side of this, I think this sort of structure is unnecessary, limiting, and potentially not wholly protective of your assets. Alternatively, and the course I would suggest to most of my clients, is to create two LLCs, one in Wyoming and one in California. Then have the California LLC be wholly owned by the Wyoming LLC, but put the property into that California LLC. In that case, if someone were to try to find out who owned that California property, they'll check title and see it's owned by a California LLC. Then they'll turn around and check the California Secretary of State's website to see who owns that California LLC, only to find it owned by another LLC, a Wyoming LLC. And then they hit a dead end. Let's say you owned a property in Oregon, or Idaho, or Michigan, or wherever. You can do the same structure as I just outlined, but swap California for the state in which the real property is located. All roads lead to a Wyoming LLC that they can't easily get beyond. So from an anonymity standpoint, you have a lot of hurdles to overcome. If you already own the property, then your name is in that chain of title, so any movements will be obvious. It's just you behind the curtain. You don't want to characterize any movements as sales because that just creates extra taxes and filings to worry about. If you plan to purchase directly into an entity, then be prepared to either have the cash up front or already have some assets within that entity that you can borrow against. And if those issues are covered, then you're going to either need a nominee trustee or some type of LLC layering. Your particular situation may vary, but I would generally lean towards layering those LLCs. One LLC for the state in which the property is in, and a Wyoming one to own that LLC. We've covered a lot of ground, so I want to just very quickly bring everything all together with my general thoughts. Remember, our focus here is on California real estate investing. If asset protection is your primary concern, then go with an LLC. You get the limited liability that is absent from a revocable living trust and the flexibility that's absent from an irrevocable trust. Property taxes are reassessed at certain transactions. In California, there's no reassessment if you transfer the property to your revocable living trust or your own LLC, so you can go either way here with a slight edge for the LLC. You can transfer ownership of that LLC without triggering a reassessment, but only up to 50%. Anything beyond that reassessment, if you transfer any percent of that property outside the LLC, either directly or through the trust, then reassessment of however much was transferred. Next, for due on sale clauses, we're generally all right with either the revocable living trust or an LLC. However, once you get third parties involved, you run the risk of triggering that clause and thus having to pay the loan back all at once or to requalify. And finally, from an anonymity standpoint, your particular situation may vary, but I would generally lean towards an LLC here and layer the LLCs if you want to make sure you cover yourself as much as possible. Keep in mind that whenever you are creating an entity like an LLC, you need to register that entity and the owners with FinCEN under the Corporate Transparency Act. That's not a public database, but it is a database all the same, and one that carries heavy penalties for non-compliance. I've got a few videos here where we've discussed that. All right, how was that? Clear as mud? Do you know what you prefer to use for your real estate investing, a land trust or an LLC? Do you think all this is silly and doesn't matter because the government, or more likely big tech, already knows everything about you? Let me know in the comments below. Thanks for watching. Be sure to like, subscribe, share the video with your business partner. I'm attorney Andrew Bethel, and I'll see you at our next meeting.